Okay, let's get started. Good evening, everyone. Good to see that so many of you and some people returning after a long absence. Well, apologies for the delay, but as you know, we are recording all these sessions because they provide very valuable materials for both teaching and research, and they also help us build a bit of a history for the Manchester International Centre. So actually all these lectures are put online afterwards, at least as long as our distinguished speakers agree to be recorded. And Professor Jure Vidmar has kindly accepted to be recorded tonight. So this is the reason for the slight delay. Let me introduce our guest tonight, even if he doesn't need any introduction. Professor Jure Vidmar, Chair of International Law at the University of Maastricht, after having held some very prestigious position in Europe, in Oxford, in Amsterdam. Well, he's a very, very prolific author, having written on all kinds of topics. I mentioned only a few. Of course, statehood, which was your first love, if I may say, and you've published this wonderful book on the democratic statehood with Hart a few years ago. You've also directed a book on hierarchy in international law. I think your inaugural lecture was on state responsibility. I mean, just to show the broad character and the broad scope of your research. And today you'll be speaking about the use of force. So I don't think that generalist scholars are endangered species. So you are at least one of them, surviving the great specialization of the field. You'll be speaking about the use of force and focusing on a very intriguing distinction, which is a distinction between the state of necessity and self-defense. And we all know, at least those students who took the course on use of force this semester, still have this very vivid memory that the court, in the advisory opinion on the Wall case, didn't help us distinguish between the two, or at least brought in the debate on state of necessity into the realm of the use of force. Professor Vidmar will be speaking about the distinction through a very timely debate, which is a debate on the doctrine of unable and unwilling, and this is a debate that will allow him to revisit the distinction between the state of necessity and self-defense. So that's as far as I had promised you a short introduction. It was not so short in the end, but I really wanted to make the audience appreciate how lucky we are to have you tonight. So thanks for traveling to Manchester. You'll be speaking for 30 minutes, and then we'll have time for discussion.
Thank you very much, John, for this kind introduction. It is very interesting to hear from you that I'm a prolific writer, because then I don't know how one could describe you. But I will talk on the use of force, as you said, on self-defense, on necessity, and I will contextualize that with non-state actors. So the so-called use of force against non-state actors, which is hotly debated these days. This happens in the context of the so-called unwilling or unnecessary doctrine. So where states are considered to be unwilling or unable to prevent an armed attack from happening on another state, but from the territory of that state. We have now the second installment of the so-called unwilling or unable doctrine. So the first time around, I think it came in the context of humanitarian intervention, when the Security Council is deemed to be unwilling or unable to authorize force for humanitarian purposes. But now we say that states are unwilling or unable to prevent a non-state actor from abusing its territory to mount attacks on other states. Now, if we look at the the broader puzzle a little bit, right? We have Article 2.4, and then we have two exceptions, or I will call them justifications. Security Council authorization and self-defense. This is then a way out of illegality. How you can use force yet not get caught by Article 2.4. So if you have Security Council authorization or if you have a valid claim to self-defense. Now, the problem being is that international law is conceptualized prima facie as a system applicable between states. So I can say here that I'm quite a traditional that I'm quite a traditional international lawyer, but even if I were not, I will explain why we would still have the same problem that I'm going to discuss now. So in order for Article 51 to be triggered, so an armed attack must have occurred. And an armed attack, in my view, can only come from a state. So how did we suddenly start to accept that some non-state actors, for some purposes, do have international legal obligations and can violate international law? So why some non-state actors can mount an armed attack on a certain state and other non-state actors do not have the capacity to breach international law at all? So for some purposes, it is doctrinally quite unclear to me why and how did we get there, that some non-state actors are debated to have this kind of international legal capacity. Yet, even if we accept this, and in my view this claim is very problematic, the problem is then in the second step. When an armed attack has occurred, and if we accept that, for example, ISIS can attack France, what happens afterwards? So then France has the right to self-defense, fine, but ISIS doesn't have a territory in the sense of international law. So where does ISIS then, so where does France then exercise its right to self-defense? Well, in my view, France does not need to have any Article 51 UN Charter self-defense to exercise it in its own territory, because that is not prima facie caught by Article 2.4. So resorting to force within own territory does not fall within the scope of 2.4 prohibition, and hence the state does not need any justification, and Article 51 here works as a justification. So the right to self-defense only becomes useful, in my view, or states can resort to it when they cross the border. So when they use force in the territory of another state. They do not need it in own territory. Of course, this is not a carte blanche. Self-defense in international law, as in domestic law, still needs to be necessary and proportionate. But let's assume, so there's this whole other debate when self-defense is necessary and proportionate and when this has been overstepped, but let's assume that the state is exercising its self-defense when this is necessary and proportionate in the circumstances, and this gives then the state the subject to this, to test the right to act, to use force beyond its borders. And here then we come to a problem when states want to exercise defensive, so want to use defensive force, as it is called, in the territory of another state, but that state did not attack them. And the non-state actor attacked them, but the non-state actor does not have a territory in the sense of international law. Say France uses force in Syria. How did we get to Syria? Syria did not attack France. ISIS did. But then the argument is, but Syria is unable or unwilling to prevent ISIS attacks on the French soil. How did we get there? In my view, we get there because we attributed the armed attack to Syria, because Syria was unable or unwilling. And this is very problematic. First, if you look at this concept of unable or unwilling states, unable is not quite the same as unwilling. So if you are unwilling, you may be a little complicit here. And we may say that the Taliban government of Afghanistan may have been complicit in some Al-Qaeda activities due to a strong link between the government of Afghanistan at the time and Al-Qaeda. And that maybe being unwilling did provide that sufficient link. But if you're unable, this sounds to me a bit like strict liability. So Syria may be doing things to drive ISIS out of its territory, but is unable to do that, yet we still attribute the act to, so we still attribute that conduct to Syria. So how did we get that? I think we suddenly pulled strict liability out of the sleep. And I think it is quite unclear whether we have something, whether we actually have a concept of strict liability in international law. We may for some purposes, but not others. But then I think there is no legal certainty governing this issue, but rather policy choice. So political expediency and policy choice, in what circumstances we will require a degree of fault, and in what circumstances we would apply strict liability. So now, and this is how I think we got to discuss self-defense in the context of non-state actor, when an armed attack does not come from a state but from a non-state actor, because we attributed that armed attack to a non-state actor. I will say here that scholars have now been debating this also in the context of so self-defense against non-state actors in the context of the law of state responsibility. I'm quite interested in the law of state responsibility, and I will make an argument that this really is a good way forward, and in this context then I will come to necessity under the so it's captured under Arsiva, but let me first go step by step. There have been some approaches, so I will first say why I disagree that we should be talking about self-defense in this context. So in one view, Article 51 of self-defense gives states the right to self-defense when an armed attack has occurred, but then there is also self-defense under the article of state responsibility, which arguably gives an excuse to the self-defending state for wrongfully using force against a non-state actor. But if it were accepted doctrinally that the lawful, so if it were accepted doctrinally that this kind of separating Article 51 as a justification and Article 21 Arsiva as an excuse we would need to then also accept the strict separation of our SIVA and the so-called primary norms, to which I will come later, so that we have under the Charter we have justifications, and under the RSIVA we arguably have excuses. And I do not fully agree with that, and we'll come back to that later. But then we have another view, that Article 51 gives states the right to self-defense, but then Article 21 of our SIVA is needed for an exculpation of self-defending states from certain ancillary breaches that happen in pursuance of self-defense, such as the principles of non-intervention and state sovereignty. But if it were accepted again that the lawful exercise of the right to self-defense under Article 51 leads to ancillary breaches of the principle of non-intervention and state sovereignty, one could then ask, what does Article 51 authorize at all? So resorting to force within own territory, as I said earlier, can prima facie not violate Article 2.4. And why would then the defending state even need the Article 51 exculpation? In other words, the concept of these so-called ancillary breaches in the exercise of self-defense makes Article 51 normatively hollow, and then moves the whole operation of self-defense to the Articles on State Responsibility, to Article 21 of RSIVA. And then we get self-defense, which is nominally divided between primary and secondary rules, but in reality it remains undivided, as Article 51 is then left without any effect. So everything happens under 21 of RSIVA. So then this attempts at dividing self-defense between the so-called two sets of rules, primary and secondary, are consequence of what I will call a dogmatic distinction between the primary and secondary rules of international law, which has caused lots of confusion in doctrine and scholarship. And now I will make a brief argument against this primary-secondary divide. So the law of state responsibility is said to be secondary in nature because it regulates the consequences of a breach of a legal obligation, while it does not determine whether or not there has been a breach of the underlying primary norm. This is what the ICJ said in the Gabčíkovo-Nagymaros case in Hungary versus Slovakia, essentially that it is on the primary rules of treaty law to determine whether or not the treaty was suspended properly. But then it is on the but then it is on the secondary rules of state responsibility to determine the consequences in case that the treaty was not suspended in line with the rules of treaty law. This sounds quite reasonable. It is the two-step approach. Wrongfulness is identified under the primary norm, and once this has been done, state responsibility then determines the consequences. But the problem is that this approach only works where the conduct we are analyzing can by definition only be an act of state, which were the factual circumstances in Gabčíkovo-Nagymaros. So in order to suspend a treaty, rightfully or wrongfully, you need to be an organ of a state. I cannot do that. But then not all conduct in international affairs is prima facie an act of state. If there is an airplane shot down, or a civilian aircraft shot down over a territory of Ukraine, over which Ukraine has has no effective control, it may or may not be an internationally wrongful act, depending on whom we can attribute that action. So the MH17 in the background. So here then we first need to see whether or not we can attribute that conduct to a certain state, and only then, so we need to do attribution first, and only then do we decide or can we establish whether or not there has been an internationally wrongful act. In a sense, the ICTY also did that in Tadic and was heavily criticized for doing so. But I don't think that criticism was entirely justified, as how else could the ICTY establish whether or not the armed conflict was of international or non-international character? It first had to establish whether or not it was certain actions were attributed to the Federal Republic of Yugoslavia. So now here I try to make a very brief argument in favor of abandoning this dogmatic distinction between primary and secondary rules, and proceeding on the assumption that primary and secondary rules of international law are not like polar bears and penguins, right? So who live in separate places on Earth and never meet. But we are talking about concepts that constantly interact. And here we then also come to the problem that we are sometimes faced with attempts then to hold every non-state actor bound by international law and being responsible for breaches of international law. But we need to take into account that in every legal system we have actors that are capable of causing harm in fact, but not necessarily in law. Because they simply don't have an adequate level of legal capacity to be even conceptually able to breach the law. So look at animals domestically. The law is by no means silent on animals. So we have certain rules regulating liability when animals cause harm and so on. So the law does, to a great extent, regulate animals. But this does not mean that a tiger would be charged with a crime of murder and go to jail for killing another animal or a human being. So factual harm caused by an animal may well be a crime or tort in law, but not that of a tiger. We will need to attribute the conduct to someone with an adequate level of legal personality in a particular legal system to even be conceptually able to commit a crime or be legally liable under tort law. And this is exactly the same with non-state actors in international law, in my view. We need attribution to states by an act or omission, and under some circumstances, attribution to international organizations is also possible. But then international organizations are bound by notably fewer rules of international law than states are. But their attribution to an actor bound by certain legal obligation, is not possible. We conceptually do not have an internationally wrongful act. Now coming back to the use of force, then, the legal rules in question, as I illustrated at the beginning, are Article 2.4 and Article 51 UN Charter, and then we need to ask ourselves who has legal obligations under these rules. It is states, but then as I said, when we have state A exercising the right to self-defense against a non-state actor in the territory of state B, we need to ask ourselves, how can a state A do that without violating Article 2.4 vis-a-vis state B? And then the answer, in my view, is because the armed attack of a non-state actor on state A was actually attributed to state B. In some circumstances, I said, it may well be plausible when we truly have unwilling states. So there is complicity, there might even be fault, like the relationship the Taliban government of Afghanistan and Al-Qaeda. But when we have unable states, I think we are in a much more difficult argument to make. Now, moving a bit further, and I will then bring everything together toward the end, I said that I didn't believe that a separate concept of self-defense should be conceptualized under Article 21 of our SIVA, and that the distinction between the primary and secondary rules is artificial and has become even dogmatic and illogical. But let's look at Article 21 and the whole concept of circumstances that preclude wrongfulness under our SIVA. Now I'm moving toward necessity as well. First of all, how could the so-called secondary rules on state responsibility preclude wrongfulness if they didn't interfere with determination of wrongfulness? This would seem to be a task for the primary rules. The secondary ones could then only preclude responsibility for wrongfulness, but not wrongfulness itself. Yet there is a chapter in our SIVA called Circumstances Precluding Wrongfulness, not responsibility for it. So this may be taken as another instance that proves that there is no strict wall between the primary and secondary rules. Then our SIVA lists those circumstances and that preclude wrongfulness and indeed conflate some in which responsibility may be precluded, such as force majeure, necessity perhaps, and others which actually preclude wrongfulness itself, self-defense, under 51. Article 51 is indeed a way out of wrongfulness mandated by 2.4 of the UN Charter. It is a legally warranted departure from the original prohibition on the use of force. But then on the other hand, when we have a military aircraft violating the airspace of another state due to bad weather or mechanical failure, this is not a legally warranted departure from the original norm. So wrongfulness is still there, but force majeure may preclude responsibility for it. So I think in this defenses under, in the concept of defenses under SIVA, so titled Circumstances Preclude Wrongfulness, we have the very typical conceptual distinction between justifications and excuses, as is known in domestic law. A justification being a legally warranted departure from the original prohibition, as we have in domestic law taken life in self-defense. So an act may be prima facie wrongful, but justification takes you out of illegality altogether. Or we have excuses such as emergency drivers. So it is not legal to drive too fast on the way to the hospital trying to save somebody's life, but you may well have a good excuse. And it is then indeed some early drafters. Then why is this interesting in this concept of self-defense? Is that some early drafters of what is now our SIVA believed that the use of force was always prohibited, no matter what. And not even Article 51 of the Charter was seen by them as a justification. It was seen as an excuse. And this is how then it got included in what is now Article 21 of RCEWA, and it was nothing else but reflection of Article 51. And since this was in the law of state responsibility, this was intended then to preclude responsibility rather than wrongfulness. So it was how some people conceptualized that like that. But then it is now having afterlife. So I think Jean's new book actually demonstrates how certain concepts then just became accidentally developed and then get some sort of afterlife because of a strong belief in that. And I think this primary-secondary divide is a very good example. And also this article, that Article 21 of RCEWA regulates a different subject matter than Article 51 of UN Charter. I think this is also a bit of a myth. And of course here the law of state responsibility was seemingly an appropriate place to accommodate self-defense as an excuse, which was seen to be at the time by some writers, because they thought after World War II that the prohibition on the use of force needs to be very strict, so there is no justification but possibly only excuse. The division then between wrongfulness and responsibility then got further blurred later, but Article 20, or what is now Article 21, stayed, and then we have a confusion which is manifold. We have the law of state responsibility, which doesn't regulate responsibility for wrongfulness, but actually also whether or not there in fact was an international wrongful act. We have circumstances precluding wrongfulness in the body of law, which ought to deal only with responsibility. Then the chapter on circumstances precluding wrongfulness blurs justifications and excuses. The self-defense, I think, is a typical example of a justification, as it is a legally authorized departure from the general prohibition on the use of force. But now coming back in a full circle, because we find self-defense also in the Articles on State Responsibility, some have started to interpret Article 21 self-defense as an excuse as opposed to Article 51 as a justification. So the mess is complete. And here I'll now come back to what I said at the beginning. So if we accept that a state can use force as a matter of self-defense in the territory of another state because it was attacked by a non-state actor who operates from the territory of that other state, the only plausible legal mechanics is attribution of the armed attack to the unable state via strict liability. But I find that very problematic. So how did we out of a sudden materialize strict liability in international law? It is a bit unclear to me. And now I will say that what may be more plausible is necessity as a defense in its own right, not necessity within the concept of self-defense. So defensive use of force is subjected to necessity and proportionality, but necessity can be also a self-defense, can also be a defense in its own right. As professor and special rapporteur Crawford, as he then was, noted in his comments to RCEWA, Caroline has always been about necessity rather than self-defense. It is indeed hardly conceivable that Caroline would be self-defense at the time when Article 2.4 or its customary reflection didn't even exist. Note that the Caroline incident happened more than 100 years before we had UN Charter. And also that Caroline was about using force in the territory of another state in order to avert attacks of a non-state actor. And doesn't this sound quite familiar? It may well be that we have the true Caroline doctrine at work in Syria, not Caroline as expanded self-defense. So not Caroline as anticipatory self-defense, as it is often, in my view, misunderstood in international legal doctrine. Another one of those myths that somehow got perpetuated in legal scholarship. But we may have Caroline as necessity, which may be conceptualized as a justification and not as an excuse. And I think it is not the first time that we are faced with the concept of excuses in international law. Doesn't the idea of humanitarian intervention without Security Council authorization sound exactly like that? An excuse. So, say after Kosovo, the phrase used was it was illegal but legitimate. This is precisely the logic of excuses, the very logic of an emergency driver. And here again, I think with necessity, that Caroline has never been self-defense, so it has always been necessity and has existed as an excuse in international legal order. So now, in conclusion, I believe that rather than digging deeper into the arbitrary and artificial gap between the primary and secondary rules of international law, like separating 51 UN Charter and 21 of our SIVA and developing complicated theories about that, we need to develop a thorough typology of justifications and excuses, and also so that we would say self-defense as a justification, maybe necessity as an excuse, and consider how we could use necessity also as an excuse to use force under some circumstances, which I think is happening right now. Just then, states and scholars try to brand, to subordinate that as self-defense, which I think is a wrong label for what is going on in state practice at the moment. What is more, I think we need to seal this major structural crack of international law, which is very limited international legal capacity of non-states, combined with a high Nicaragua threshold of attribution of conduct to states. So this is not a call for more research on non-state actors, so in the presence of Jean, who has done quite some research on that already, and I think he has already pretty much exhausted the topic. But I think we need to now to do more work on the inadequate and failing system of attribution. I think attribution is a weakness of international law. It's kind of a transmission system that applies the rules of international law to real life events, to the conduct. And this transmission system is completely faulty. On the one hand, we have the very high Nicaragua threshold for attribution of actions, but apparently we can, under some circumstances, just decide when we would have strict liability for omissions when we have an unable state. So I think more work needs to be done on the concept of attribution. And this is then a symptom of a structural problem of international law in general. And what we are, as scholars and also practitioners in legal advisors to governments, what we are all trying to do is that we are trying to suppress this structural problem of international law in certain then subfields of international legal regulation. So then we have a mighty non-state actor that can do lots of harm in fact, but then we do not know how to exercise self-defense because we do not know how to regulate the concept of attribution effectively. Then not to mention, say, situations when we have unclear territorial status of entities. So, for example, I've been always asking, so is Taiwan protected by Article 2.4 vis-a-vis China? And say if a third state attacks Taiwan, is that actually an attack on China? And does China have a right to self-defense against a state that would attack Taiwan and so on? So there are very many difficult conceptual problems here, and I think the origin of all of that is that we have not done enough work on the concept of international legal capacity. So we have a sliding scale of international legal capacity going back to the reparations opinion, but it was never clarified how this sliding scale works, and the concept of attribution, which I think is also quite unclear how that works. And these are the structural problems, but then when we then have the unwilling or unable doctrine at stake, then we just don't know what to do with it, right? So, and then we create sometimes some strange theories, and I think we would need to have more conceptual work on international law in general, rather than just focusing on substantive sub-areas and trying to suppress some pressing problems in these sub-areas because we are just suppressing the symptoms. And now going back to the beginning to conclude, I think this is also the reason why we all need to be journalists as far as possible. Thank you very much for now.
I wanted to hear your thoughts. There's a line of argument in scholarship which I've come across, and I'm guessing you've definitely come across it as well, that it's not that actually the war on terror is a different kind of phenomenon, and we don't know enough about this factual situation, and that's why we're trying to apply articles that don't really apply to it, because it's sort of novel and the law has not progressed enough yet.
We can take them one by one in a moment. No, hold on.
So I answered.
One by one.
Yeah, I don't think that that I would agree with that the war on terror. So I'm quite skeptical about this term to begin with. So because it's war, so how it was first presented, it was since it's war on terror. So then the law of armed conflict should apply all over the world because it's a global war. But it's one of those unfortunate examples when politicians carve a certain expression and then you try to get legal meaning out of it when you are operating with this terminology. So I do not think that separate rules apply in combating terrorism, but we need to think indeed how we would adapt or use properly the existing rules. But I do not think that would lead to a separate legal regime.
David?
So I'm wondering, the discussion on unable and unwilling as a form of attribution, how does that map onto the first part of Arsoa in terms of chapter 2? Would you see particular articles? Because I see it, you want to kind of avoid Article 21 of Arsoa becoming a sort of new rule, but then to do that, you seem to have to deformalise a lot of other rules. You have to get rid of a lot of things, and it's similarly with your argument about necessity for Article 23. There's a lot of things there that would cause problems if you start conceptualising Caroline as a necessity defence. I was wondering, did you take all of Arsoa as being there?
So what exactly would you see as a problem in the second part?
With necessity?
Either with necessity or with self-defense, that I don't see Article 21 as being creative of a separate legal regime on self-defense.
Well, the necessity requires that it does not seriously impair an essential interest. Would that not cause problems with Caroline? If you're trying to play it. I mean, my actual interest is more in the unwilling and unable, but just in general.
So if I freely admit what the biggest problem is probably that there is, in the circumstances precluding the wrongfulness, it's also stated that they cannot be invoked for a serious breach of a peremptory norm. And then some would say, and many would agree, that prohibition of the use of force is a peremptory norm. So I think it is most difficult to get out of that one. And I happily admit that. Just then, we need to keep in mind, though, that our SIVA are not a treaty. And it is it's tempting to look at it, to read it like a treaty, and interpret it like a treaty, but it's not a treaty. So in that part of the on peremptory norms came in a bit later, and maybe just doesn't fit into it properly. And secondly, so it is with the use of force, it is always qualified. So it is illegal use of force or aggression is a peremptory norm, not use of force as such. And maybe you could say that under some circumstances, so it basically becomes circular. So you could say, but this is not aggressive use of force, so it is not peremptory. So the problem of the use of force being jus cogens is that it is always, it is qualified with aggressive use of force, illegal use of force. And then you kind of get circularity here. But I think if you just look at the Arsiva framework, so this would be the most difficult part to reconcile my proposal with the law on state responsibilities.
So then to that extent, you don't take Arsoa as being all part of custom or needing to be interpreted that way. It's somehow
so it is for the most part reflective of custom, but for most it is not a treaty, so you cannot put together everything that it would work so neatly as a treaty, almost in a mathematical way. So I think there is some room for much more room for interpretation than it would be had it been in a treaty.
Before going to the first word, you heard that Brazil now is pushing very hard in the UN to get a treaty on the Articles on State Responsibility.
Yeah.
So let's see but that the countermeasure part will be excluded.
But then also the problem of treaties then will be not all states will ratify it, and states will file reservations probably, and then we will get a total mess. So I actually wonder whether this is a good development.
Yeah, and the proposal includes all parts of the articles but countermeasures. So if there is a treaty, then it in a way casts some doubts on the provisions on countermeasures, which will not be included. Sorry for interrupting.
No. Listening just makes me think that it all becomes like a problem of interpretation. of the Article 51, but the case law in this case we have many examples and different examples on how a state has reacted to an armed intervention in their territory. We have cases of Israel against Hezbollah in Lebanon, or we have the reaction of the United States over the decline on Lockerbie and the reaction against Libya. Cases are very different. So is it just an interpretation of the Article 51 on exceeding the power of responding to an armed force? Or do we have to interpret that, or it's just a question of interpreting every single case in a different way? Because cases are very different from one another. Where can we draw the line?
Yes, I mean cases are quite different from one another, but it can be so. I think you're referring here when force is used against a non-state actor.
Exactly, that's all.
Yeah. So not like all instances of 51. But my point being here, it shouldn't even be a matter of 51. It should rather be a matter of necessity, like going back to Caroline, as it originally was. So acting against a non-state actor in a territory of another state, and to drop the talk on self-defense in this context, because I don't think it is just blurring Article 51 and what it actually is. And for Article 51, I strongly believe you need to have an armed attack, and an armed attack must come from a state.
Well, in the case of Israel in 2006, they responded to an attack from a non-actor state because it was Hezbollah from the Lebanon territory.
Yeah, and I would claim this is necessity rather than self-defense.
But then the UN had condemned Israel for the intervention, so it was not necessity then anymore.
Yeah, but necessity is an excuse rather than, and so the act was still illegal. So the act was still illegal, but it may well be.
What was it illegal?
So that use of force in such
from
a case,
Israel,
that could still be seen as an illegal, but potentially excusable rather than justifiable. Yeah.
Okay.
So this is the line of thinking I'm trying to advance here, that we should try to think more in the use of force along the lines of justifications and excuses. So as we have lots of excuses logic, but we try to present it as justifications, just like humanitarian intervention. It is often seen as a way out of illegality, which it shouldn't be, because then the Charter framework will be completely eroded if we try to pack too much under self-defense, or if we try to hit here under self-defense, or if we try to create a separate customary exception or customary justification for humanitarian intervention. And we would drill too many holes into the prohibition of the use of force, and this is why domestic legal systems then on a case-by-case studies, case-by-case basis, they may accommodate excuses, and I think we have something they can. So not all, and I think we have something going on in international law for a while. So starting with
justifying the response
with India's intervention in Bangladesh, for example. So we have something going on there, and I think it has not been properly captured.
So I have Phil, and then I will add myself to the list.
Questions maybe a bit low-hanging fruit, but it's just in the sense that It seems to me that it's not an area I know all that well, but it seems to me that for a very long time there was an effort to exclude necessity from this area, from the use of force, because it's so subjective. And there's been a very extensive attempt to exclude, to minimise necessity within the framework of state responsibility. And it just seems to me that I think you have a very good point about the quality of the drafting and the quality of the distinctions made between responsibility framework and the charter. But it seems to me that we're just the sort of bringing this, a lot of the main contradiction we seem to be facing is that to enable a minority of states to carry a big stick while dressed up as dogs. And I don't see that as a particularly good reason to open the gates on necessity.
Yeah, so I agree with your skepticism, and I do not claim that this is not without any problems. What I'm suggesting here, because then is this so the main problem, and also something that I'm happy to admit, is that can we have the concept of excuses functioning in international law the way this is functioning domestically? Because we do not have centralized compulsory judiciary. And then states would be self-interpreting. And then if we move this kinds of uses of force from self-defense to necessity, then we just shift it into another category, but state will still be self-interpreting. And so what did we do in the end? But then I see, so my argument is, though, that first of all, this is a problem of international law in general. So, and then then we could scrutinize every concept in international law. Yeah. So does it even work the way it does domestically? And then we can come back to this never-ending debate whether international law is law properly so-called. And then secondly, I think it is, just like in domestic law, important to leave certain concepts that are, and admit they are illegal, but you may get away with it, so that responsibility will be precluded, but the act will remain illegal. In order to discourage abuse. And there is another problem in international law. State practice may then, and opinio juris, create new custom. And here, if we say these kinds of uses of force are illegal in international law, though may be excusable, but they're illegal, that will not generate state practice for modification of the existing customary rules. And I think if we accept this too liberal expansion of the law of self-defense, so custom will just allow for too many situations to fall within self-defense, which will be then states self-interpreting their own legality.
So again, if I can, so you think that would the definition of necessity not then also be subject to sort of an inflationary dynamic with respect to custom? Could we end up with a progressively growing definition of necessity in the same way that we could end up with?
Yeah, but that the use of force would remain illegal. Yeah, but it's a tough one. Yeah, yeah. It's also I think what I need to do also to go back to the drawing board and try to logically think through it. So because what would the benefit be at the end of the day of moving it? And I think the benefit would be, it's like with the if speed limit is outside here is say 50, and then if then the sign said, well, 60 if you're rushing somebody in hospital with broken leg, then 2 legs broken 70, heart attack 80. So then you, at the end of the day, you don't know what the speed limit is, and you invite a wider disobedience of the rule. And that's why I think also we should protect the existing charter rules and then try to consider certain excuses on a case-by-case basis. And not undermine the charter rules. So to remain, so some would say we should abandon this orthodox reading of the charter, and I think the orthodox reading of the charter is the only plausible reading, otherwise we will completely dismantle the system of the prohibition of the use of force.
Well, there are obviously many doctrines and rules you're unhappy with. I mean, the law on strict responsibility, the use of force, the distinction between primary and secondary rules.
On the use of force, I'm quite happy with those rules and want to protect them.
Yeah, actually, that's right. Actually, you're quite lenient and you're quite protective of these rules. I think your real target actually is the law of state responsibility. You really want to revamp and reinvent state responsibility. You're unhappy with wrongfulness, you're unhappy with attribution, you're unhappy with circumstances precluding wrongfulness. So you want to rewrite the entire, you want to kill Crawford and replace him and rewrite the entire project on state responsibility. I think that's your real target. I mean, listening to you, and the thing is, I must say that I've listened to you in the past, and where you, on occasions where you also took issue with state responsibility. But I think that you really want to reform state responsibility because, and you say repeatedly, it's inconsistent, it doesn't make sense, it's a mess, and you use it, which means, and that's my first remark, that you still believe it's possible to have sleek, consistent doctrines. So you're still a believer, when I think of it. You believe into sleek argumentation and consistency. Obviously, the articles on state responsibility are awful. Obviously, the circumstance precluding wrongfulness in Article 20 and 21, I mean, all what you say about self-defense in circumstance precluding wrongfulness could be said about consent. It's not circumstance precluding wrongfulness, it's circumstances precluding illegality. So I totally agree, and all the rest, I mean, but so you cannot live with messy doctrines. So you still believe in consistency and you want things to be nice and clean and clear. And so that's my first remark. So you think it's possible to have doctrines which are completely watertight. First point. Second point is, and it ties in with what Phil said, which is, are you a restrictivist or an expansionist in terms of use of force? And my second remark is about the use of force. Because obviously, as Phil said, you add another excuse. Well, to be honest, you say you're an orthodox, but I think for once I'm more orthodox than you, because I do believe that the UN Charter excludes the circumstance precluding wrongfulness. I do think that the UN Charter comes with its own regime of excuse, which is self-defense, and self-defense has the monopoly of excuse under the UN Charter, and it's in that sense a lex specialis. I know that if you're going to object, well, the notion of circumstance precluding wrongfulness came after the UN Charter, but I side with people like Olivier Courten, who says that, well, the regime of state of necessity is inapplicable, but still, I'm ready I see your point, but then the question is, you seem to be an expansionist. You want to expand the freedom of states to use force. Because you just multiply the grounds on which you can justify use of force. Your point is, well, because if what we see at the moment is a slippage with self-defense, but if you introduce state of necessity, you're going to have another slippage. So you just multiply the avenues for slippages and expansionist interpretation of the excuses. So that's my second point. With whom do you side? With the Oaks or with the restrictivist? And lastly, because you ended your talk, and that's more an epistemological remark, you ended your talk saying we need more work. So we need more research. Or is that a self-justificatory move to say this is the research I'm doing right now, or behind this there is a strong, and again I think you're a believer, you believe in research, you think research can contribute to these debates. So do you think that the research we carry out on attribution or the use of force will improve the debate and will, I don't know, tighten the constraints on what states do in terms of use of force? So what's your views on research? Or what do you mean by we need more work? So that's just 3 brief remarks before we can have drinks.
Can I start with the third one?
Mm-hmm.
So it was not going to be a call for more research on the use of force, because use of force is exactly one of those subfields when we are suppressing the problems. And I think more research is actually needed on the notion of international legal capacity and on attribution. So, and the law of responsibility is also very strongly linked to the law of legal capacity. So we have Arciva, we have Dario, and that's it. So then and this already indicates which actors have international legal capacity. And then, of course, then we have individual criminal responsibility, but this is a very peculiar, separate regime, which actually also comes from treaties, but it's quite separate and quite special. But in principle, yeah, we have states and to an extent international organizations. So I think there is a link between the law of responsibility and the law of legal capacity, and on which we all need to do more work, and on state responsibility, which I think to an extent we do need to clear a mess. And I wanted to say this to the audience of younger scholars, so that they wouldn't perhaps, that some may well want to jump directly into certain subfields of international law, but you and I started with statehood. And democracy and international law. And now looking back, maybe this was not the best focus to begin with for a PhD. So maybe actually taking on a journalist conceptual topic is actually much better to think what international law can and cannot do. And when I was writing my own PhD, I think I sometimes expected too much of international law without asking myself what actually international law conceptually cannot even regulate. And of course, I was trying to think too legalistically. But in international law, so when sometimes we feel pressed to talk too legalistically about international law as to still be on this defense that international law is law, but then any law is political, right? So a parliament, an act of a parliament, so who votes in the parliament, it is politicians. And state practice in international law, who is running the state, politicians. So here in international law, we are just dealing with different actors on a slightly different level, but it is not that different than domestic law. And here also my idea is that we should detach international law too much from a general legal science. So that for a good international lawyer should first be a good lawyer. And I specifically say that to the group of younger scholars. Now, state responsibility, do not. So it is the second time you say that here I want to destroy Crawford, but I do not blame Crawford because he didn't create the mess. He inherited a lot of it, and also he did whatever he could, and he personally, I think, has quite some view on these issues. But what I want to do is exactly, I think it is worthwhile talking and writing about this dogmatic distinction about primary and secondary rules, about 21, Article 21 of our SIVA that has started to kind of live another life and taking off meaning something that it was never supposed to mean, precisely because of this, taking this primary secondary divide further on. So it's primary. Some would say self-defense under 51 is primary, but secondary is because certain secondary breaches come with defensive use of force. I think this is attaching yet another meaning to the concept of primary and secondary, and we need to be careful that we do not. So when other scholars or states even are creating such mythology, that we are here a bit more myth busters. And I do think so that state responsibility, why I talk so much about state responsibility, it is because it is in state responsibility, it is very much about how international law works as a concept. I don't really see it as a separate subfield of international law, but I see it how international law operates systematically. So it's kind of a systemic glue of this legal system. And then it's interesting to see textbooks on international law, and then authors never quite know where to put state responsibility. You always find it in some odd places, often at the end, right then next to dispute settlement. But I think state responsibility probably belongs at the beginning, because it is very much, so what international law can and cannot regulate. I think it should come after sources. And here, if we are talking about international law conceptually, my view is we need to talk mainly about state responsibility. And because there is so much mass in it, so people develop theories, and states also go for that can potentially be harmful in my view. Coming back now to your provocative question, whether I interpret the use of force restrictively, or am I an expansionist? In a sense, yes, you are completely right. I feel you are completely right. I interpret the Charter rules very restrictively, but then I am an extra Charter expansionist. But why I do that is that state practice is already overtaking us. If we want to be restrictive about the Charter, the problem is that state practice is going on. Then we have some influential writers who say that window in Article 2.4, that second part, they interpret that as a window against territorial integrity and political independence. So if you are using force in another state but not against political independence or territorial integrity of that state, so then you fall out of 2.4. I think those interpretations will completely undermine the charter system. And I think that then being expansionist in a certain way, by keeping the extra charter use of force illegal, but potentially acknowledging excuses, actually preserves the strength of the charter. And then, as in I think 1972, Sir Nigel Rodley and Thomas Frank were writing, however, every legal system knows for mitigating circumstances, and maybe we need to acknowledge that also in international law, that we do have mitigating circumstances. And I will stop here.
And that's a very nice ending, also another polemical ending. Well, you've been very polemical, and that's what we wanted. So thank you so much for coming and for providing us for food for thought. So you deserve at least another hand.